I'm calling to order the Tuesday, April 1st, 2014 meeting of the Township of South Orange Village Board of Adjustment. May we have a roll call?
Yes, Mr. Dom?
Here.
Mr. DeScalo?
Here.
Mr. Reeves?
Here.
Mr. Semper?
Here.
Mr. Aller?
Here.
Mr. Shapiro?
Here.
And Mr. Breen?
Here.
Pursuant to Section 5, Chapter 231, PL 1975, this is to state for the record that adequate notice of this meeting has been provided to the public by posting and maintaining the annual notice of regular meetings on the bulletin board in Village Hall, by publishing the annual notice of regular meetings for 2014 in the December 2013 edition of the South Orange Maplewood News Record, and by filing said notice in the office of the village clerk. Okay, so the first order of business this evening is approval of minutes of the meeting held on Tuesday, March 4th.
They were brief.
Yes, they were brief.
I moved that we accept them. I second.
You didn't let me ask. Do we have any comments on the minutes at all? No. No. Okay, may we have a movement?
I move to accept them.
Thank you.
I second.
Okay. Miss,
Mr. Dom?
Yes.
Mr. DeScalo? Yes. Mr. Reeves?
yes.
Mr. Semper?
I abstain, was absent.
Mr. Aller?
Yes.
Mr. Shapiro?
Yes.
And Mr. Breen?
Yes.
So then the next, or I think we have some outstanding oaths of office.
There is one for Mr. Semper.
Oh, wait, Mr. Semper, that's it.
Well, that's the notary. Do you want to read
Oh,
that,
man.
read it in the record? I signed it.
Yeah, have him read it into the record, please.
Can you read that into the record, please?
Oh, man. I, Edward Semper, do solemnly swear or affirm that I support the Constitution of the United States and the Constitution of the State of New Jersey, and I will bear true faith and allegiance to the same and to the government established in the United States and in this state under the authority of the people. And I do further solemnly swear or affirm that I faithfully, impartially, and justly perform all the duties as a member of the South Orange Zoning Board of Adjustment according to the best of my ability, and that I will not use my office to grant preferential treatment, nor to seek personal gain, favor, or disadvantages not available to the public. So help me God.
Thank you. The record will reflect that Mr. Parlapiano arrived. Okay, there's several orders of business tonight. No actual full-fledged application this evening, but we have a completeness hearing that we'll hear towards the latter end, and we'll take care of these side issues now, including at some point we'll go into closed session. So, Mr. Dwyer, you'll help me on this. I have no particular order on this. I think we should mention Seton Hall will be carried to May's meeting, at least as far as we know right now. Is there anything further to discuss on that here in public?
Sure, Mr. Chairman, there was a request by the board for me to contact, if I could, the attorney for Marylon, who's involved in litigation with respect to neighbors and the restrictive covenants that exist in that area. I did. I contacted Mr. Cornwell and was advised that there are settlement talks that are being undertaken at this time, and that he was hopeful that they might actually reach a settlement and not have to go through a trial. So it may be resolved, according to him, in quickly as 60 days.
Okay, that would imply, though, that they probably won't be coming to the May's meeting.
Seton Hall, I did put a call into Seton Hall's attorney, but I hadn't yet gotten a call back with what their plan would be in the event that it resolved. I assume they'll come back here.
I may be able to add a little to that, because actually this morning I was out not on the Mary Lawn application, but I was on site with some of the Seton Hall representatives regarding the University Center and the follow-up with the planning board application with that. And it was raised about the application in front of this board. They, Nicole, the Seton Hall's attorney, did seem to indicate that they would be here for the May meeting.
Okay.
And and seem to reiterate what Patrick has already said.
Okay. Okay, so then we move on to,
Can I just ask again, I asked this last time about the nature of the settlement talks going on and the relationship between those settlement talks and the application that's in front of us. Is there any relationship between the two?
I think it's the only relationship I'm aware of is the applicant's reluctance to proceed with the land use application while there's still uncertainty about those restrictive covenants.
But if the restricted covenants are, if their issues with the deeds are resolved, then the application with us proceeds, but is not in any way there's no impact of that other than it removes a deed restriction that might otherwise have come up in a hearing in front of us.
Actually, the board has no jurisdiction over the deed restriction, so they could, if they wanted to, proceed with their application, get an approval, but not be able to build because of the restrictive covenants, so I think they prefer to wait.
And the resolution is not, of the deed restrictions, is not specifically with, it is a resolution of an issue that would be on the deed for whoever owns the property, not
Correct.
specifically Seton Hall.
That's right.
Yeah, okay, thank you.
if by chance they came before us with these deed restrictions still in place, that's an if, is that something that is that something that we as a board are even allowed to consider? Well, this was the intent of, the character of the neighborhood for many years, there would be single-family properties. Is this something that we take into consideration?
Actually, whether or not there's a restrictive covenant that would prohibit a particular land use application is not supposed to be relevant. The board's only supposed to judge the application based on the ordinance and the state law, the MLUL. And if there's a private contract to the contrary, that's to be worked out elsewhere.
Okay. Any other questions about Seton Hall? Okay, why don't we then move into Fairview Avenue? And you all should have received in your emails 2 letters, one quickly following the other. In short, the applicant for Fairview Avenue has withdrawn the application. They said that they intend to come back in very short order. And they can come back without prejudice. If they do reapply, they volunteered to renotice, but I think we should certainly require them to. It's been a year, I believe. And just like when we grant the variance and somebody doesn't begin construction or movement on that variance after a year, our ordinance makes that variance void.
I think it's 9 months in our.
Okay, so well, certainly then, along those lines, the analog here of, it's been over a year, everybody's forgotten about this, conditions might have changed where they're proposing the use change, so that's another reason to renotice. So do we need to let them know that, yes, they must renotice when they,
Well, they
is
would
that
have
sort
to.
of understood?
They would have to, since it's a new application, but I did have a conversation with the attorney for the applicant today, and he had a request that he not be required, if he refiles the same application, to resubmit all the plans which the board already has, and I said I would raise that this evening and ask the board if that's something that they would consider.
Does everybody have the old stuff?
Yeah, it's getting kind of old, right?
I don't.
Well, it's old, but it shouldn't have achieved the status of palimpsest yet.
Yeah, I'm trying to think about it. So we have, certainly all the stuff all the memos that have been delivered on email I have, right? I'm trying to think about the plans. I think I do have them.
Okay, so Mr. Don doesn't, Mr. Descala, do you even know?
I have, this is case number 1004.
Yes.
Yeah, I've got the most recent packet, however old that is, still carrying it.
So you don't have the old stuff?
I don't think so.
Does anybody else not have the old stuff?
I don't have the old stuff.
Three
I don't have the old
no's,
stuff.
4 no's. Paul doesn't, Mr. Breen,
You sent me a package, I assumed it was
that's the
complete.
newest note.
Yeah.
So that's
I think
5.
I think I have it.
So that's at least 5, and Ms. Warren isn't here, so he's going to need to rescind at least 5. Why not just go ahead and,
Was it, how many is in the app, is it 15, Jetta?
20.
20,
That's for all the departments, I guess.
right?
well, I can't speak for the departments, they probably have it, but I think you should make at least, who here, I have the old stuff, Mr. Adler, do you?
I'm not sure, but I'm recused from that. I mean,
Okay.
I'm not sure,
Nobody
but I
else
think I
does?
still have the plans.
Okay, so as far as we know, I'm the only one that we know that has it, so he needs to make 8 copies for board members.
What if I tell him 10?
10 sounds good to me, that's even number, and it's, in the 10-digit kind of thing.
Okay.
Sounds good to me. Anything else on Fairview?
So we're starting over.
We're starting over. I mean, they may present the exact same materials or not, but that's the whole point of them starting over. Things may have changed in that area. They may have new evidence, they may not. Certainly, you should keep at this point the parking study that they submitted. Don't dispose of any of that now. Mr. Adler?
You just may want to confirm that it's still a bifurcated application.
I think this letter did, I think
Oh,
this
it
letter
did.
said it was.
Okay. Other questions about the Fairview Avenue application?
Are we going to have to hear that for completeness hearing?
To new applications, I would assume it's a new application.
Yes. Don't you?
It's a new application, so it's got to be deemed complete. before
Yes.
we heard. Is, next, that would mean that Seton Hall is going to be on next month, right, Jetta? And Fairview
But just
And
completeness.
South Orange Avenue.
and South Orange Avenue?
Yeah, Fairview would be there potentially for completeness. South Orange Dental would be on for the actual hearing. But Seton Hall's been in line. So Seton Hall would go first, but then that may, because the South Orange Dental may take several hours itself.
But there's no way we're going to get through both of them.
No,
And if we start Seton Hall, it's unlikely we would get to.
if we start Seton Hall, it's unlikely, well, certainly we won't get to South Orange Dental in that one meeting.
Right.
They can always request a special meeting if they want to. If it was clearly a very small application, we might bump Seton Hall, but I don't think that's wise to do that at this point. Okay. Right, so then we move on to some of the other issues that we can still do out here. I think the Dr. Singlet issue, that's not a closed session issue. So should I introduce that, what happened? Okay, Dr. Singla, if you recall, he's the dental surgeon who we granted a use variance on Valley Street. He wants to put his surgical office there. And just the other day, he came back and said, proposing to dispense with the flower boxes out front. I think he was going to plant some bushes, maybe a small tree there. And he wants to put in benches and pavers out front. And this, to my mind, there have been other occasions, these questions have come up, where it have just been utterly trivial changes, and I've said it's insubstantial, it's never made it back to this board. I personally think this is insubstantial, but on the other hand, it's highly visible, the change that he proposed. So I wanted to hear from the board members as to whether you wanted to make him come back. Would the process be an amendment to the variance? Is that, he'd have to testify to that? So we wouldn't have to go through the whole
No.
Michigas again.
Just to amend, is that, amend the approval?
Or we could just, by consensus here this evening, say it's an insubstantial change. I wanted to hear you all's opinion rather than make my mind up decide for that myself.
What, I certainly remember the discussion about that in the hearing, but what was in the resolution regarding that landscaping? Do we have a copy of that resolution?
I don't have the
I'm sorry, I don't have that.
The email from Ms. Davis, can they change the flower bed in front to pavers with benches for people to sit on? Sal is on vacation, blah, blah, blah. So that's all we know about. Is this substantial enough to ask them to come back and amend their application? That's what we need to decide now.
Well, it's just in text in a letter, there's no drawing of any kind?
Ms. Davis,
Nope.
we didn't receive anything. No.
They just came into the office and
I think that if you pass by there and you see the major amount of work taking
Yeah.
place there, I think that, I can't see that being, they're just doing a lot of work there. So I can't see why it would make him come back. He's really putting a lot of money and reorganizing that place.
I don't know what it looks like. I don't know how many benches.
Well, the other thing is, if he's putting pavers in, it could have an impact on coverage as well.
Right.
It seems a little bit vague to sort of just say, okay, to me.
It's a bad precedent, I would think, personally.
I mean, it would have been helpful to at least have a little drawing,
Right.
but we have nothing. I'm
I
not
wouldn't
comfortable
approve.
with saying yes to an email.
Okay. Others? Mr. Shapiro, you're about to say something?
I was going to say, I agree. I think we ought to see drawings or renderings, and then we can at least judge if it's insubstantial, and then we can go ahead and pass on it. But I think we ought to see what it's going to look like.
Okay, so that's what we'll do then. It seems like enough people think that it's substantial enough. Fair enough. So we will ask them to come back, and this is something that they can take care of next month with a rendering of what they plan to do. It doesn't require that the entire application be reopened. We're not changing any of that. This could be done, if they're organized, very quickly.
Well, is it the board's thinking that we are going to ask them to provide the rendering well in advance, and the board will at that next meeting decide whether or not those changes are substantial? And if they are, then ask them to provide testimony? Is that what the thinking is? Or the board might decide at the next meeting they're not substantial, in which case they wouldn't have to provide testimony.
Yeah, I was looking for the, I think, Todd, you were looking as well.
Well, I don't know what the case number is.
Yeah,
I
yeah.
might be able to find it. Do you know what the case number is?
I'd certainly want to compare the
I'd like that.
resolution with
Okay.
even a rough drawing of the changes, just to see what the fit is. That's what I'd like to do.
So they should send the rendering in advance so we can compare that with the rendering beforehand. If we don't think it's substantial, we'll say so at the meeting, and if we do think it's a substantial change, then they'd have to provide testimony at that meeting. Even then, I still think it should be a relatively quick
Yeah.
decision. It's,
Okay.
I'd like to see, because I don't even know if I have this, the old material, so I'd like to see the old as well as the new for comparison. A picture of what it was originally submitted and what the proposed change is.
They might be able to do that on one drawing.
That's what I...
Okay.
Ms. Gruhl?
Yes, I would recommend that if they just blow up the area where they're talking about on a plan view,
Draw on it.
right, a drawing, show what was existing and what is proposed, only for that area. You don't necessarily need the entire thing. And whatever details are necessary to show what type of bench, what type of paver, all of the details that were on the other one, the existing, what you saw and what you approved versus what is being proposed, that would be, I would suggest that would be sufficient for you to make a decision as to what it means.
When is Sal back from vacation?
Uh,
The 9th?
next week.
Right,
If we
so-
decide it's substantial, then does he have to renotice?
That's the
If you're going
question.
to take testimony?
Yeah,
That's the
because I believe there was a variance involved, although I don't think it had to do with coverage or improvements in the front yard. but there was a use variance for the use. So if we're going to amend that, it becomes necessary to renotice. So the question of whether or not it's substantial is a substantial question, because
Okay, so if we do decide it's substantial, then they're going to have to renotice, so we'll stop it there, and they're going to have to come back yet another time.
Except for the sign.
Okay, well, that's the way it goes. So you'll send them,
I'll send them a note.
So the typical protocol
wasn't
for this kind of
represented.
thing,
what?
He wasn't represented.
He had an architect, he didn't have an attorney.
That's part of the problem, maybe.
so the typical protocol for this would be for the applicant that wanted to make a change to his site plan or variance would be to submit something to the town engineer, and then they would direct it to us. And so they haven't really done that part yet. So just a matter of having them follow typical protocol.
So Sal hasn't seen this?
No, he came in yesterday. The contractor came in just kind of off the top of his head, oh, can I take the landscaping out and put up pavers with 2 benches?
Okay,
And-
well, look, Sal's not here, we need to get this information out. Let's tell them Sal can certainly opine on this, but, it's not his decision, and I want him to opine on this. But let's send that letter out to
Okay.
them right away.
By the way, can we ask him who these benches are for?
That's what you will ask? Well, that's something you should put in the letter. They should testify what the benches are.
Or they should explain. Yeah, they should explain.
Okay, so that's Dr. Singla. And we have the Historic Preservation Commission issue. May I sigh deeply?
It's not on the list, Bob.
The Historic Preservation Commission is not on the list. I went on the web this evening, and I went to the Village Code online and downloaded what I thought was the entire ordinance. It's clearly not the entire ordinance. It's only 2.5 pages. And it mentions nothing in here about certificate of appropriateness and our jurisdiction to hear any appeal of their decision. So
I better give everybody context. I don't think everybody knows.
Okay, so what happened was, there is a home on Kingman Road that was applying for a subdivision, and the Historic Preservation Commission did not give them a certificate of appropriateness. So my understanding is that kills, they can't then go even for a variance if they don't get that, but then they can appeal the Historic Preservation Commission decision to our board. And again, I hadn't read that anywhere, so obviously I'm not reading the final ordinance, but apparently that's the case.
I'm confused. I thought
Yes.
that the Historic Preservation Commission was an advisory board.
No,
Not entirely, Ms. Gruhl.
if I may, because Patrick and I went through this at the planning board level when it was referred, the ordinance was referred to the planning board, and we went back and forth on this. And to the extent that you can kind of get structure out of this ordinance, and the ordinance is dated, it was adopted July 23rd, 2012, and there are more than 2 pages. There are, on most applications, it would be advisory to the boards. However, there are 2 provisions that make it mandatory for what's called a certificate of appropriateness. In that instance, the HPC has power, okay, to deny or approve. And that deals with demolitions or relocations of historic structures and subdivisions. That's how it was structured.
Any subdivision?
Any subdivision that's on a historic site or in a district. Not just any subdivision, but subdivisions, and in this instance, this application is in the Montrose
Subdivisions of properties that are
Historic
named in the ordinance as historic?
Or in a
There is
historic
also a
district.
supplemental ordinance that identifies local landmarks, both in terms of site and districts. The Montrose District is identified on that.
as a
That is
whole.
yes, and that is the basis for the provision of where the certificate of appropriateness jurisdiction goes.
And Kingman Road is not in the Montrose Historic District.
Yes, it is. Yes, it is. And that's why it had to be referred, based upon the ordinance, had to be referred to the HPC for a certificate of appropriateness because of the subdivision trigger. Very unusual, I must say. Many other municipalities don't have that as the trigger. But in this instance, in South Orange, that is the trigger, one of the triggers.
So are there examples in other municipalities where an HPD has this kind of power?
Oh, yes. As a matter of fact, a lot of times they have more power.
Right.
Demolition is a traditional action that a HPC would have jurisdiction over and certificate of appropriateness. That's a standard one. The other, depending on whether it's a strong commission or a weak commission, it depends on how extensive the certificate of appropriateness jurisdiction is. In this instance, though, so the HPC has jurisdiction over the subdivision. Now, if it's denied, and this is a traditional way of handling it, if there is an appeal, it goes to the Zoning Board of Adjustment. That is a standard provision in virtually any other historic preservation ordinance that we've seen in other municipalities. It is the provision that it goes to the Zoning Board of Adjustment. Okay, so that's why you're getting this at this point. It's not clearly spelled out. However, normally, if there is, you either can agree with the HPC or not agree with the HPC. And if there is an appeal of your decision, it goes to the Superior Court.
So basically, it's similar to if they went to us without
Sure.
going to the HPC first, and we got a recommendation from the HPC and voted one way or the other, depending on how we felt about it.
This is a little different. This isn't just advisory.
I understand,
This
but it's ultimately, it's our decision, right?
in this instance, absolutely.
What are the grounds, I guess one of the differences is the question of grounds, right? In our case, if the case, I mean, in this board's, for this board, if the case came to us, we would consider the question of historic significance in the context of an entire case. But in the case of the Historic Commission, they're only considering it in the context of, will it change the historic character of the neighborhood or something?
Well, there are specific standards and criteria that are laid out in the ordinance, not unlike other ordinances. So there are criteria as to hardship and the manner in which they define hardship. And so the South Orange HPC utilized the criteria within the ordinance as currently. Now, in terms of, I know.
But the appeal, then, if it is appealed to us.
It has been, I gather, right? No, okay.
But if it was appealed to us, we would be applying the rules of the Historic Preservation Commission or the rules of this board?
Well, the question becomes is, and this is the conversation we've had, is it clear whether you base it on the record as it has been established, or whether it is a new hearing? That is.
Well, I'll go further and ask, is it, if there are defined rules for things like hardship that they had to apply, I would assume we'd have to review it relative to those rules, not relative to municipal land use
Correct.
law.
Interesting, though, because you're making a decision about whether you agree with the HPC's decision, not whether or not you
You're
think
not on
that-
mic,
I'm not on mic?
or you're at least not speaking into the...
I think that the decision you're making is on whether you agree with the decision of the HPC, not whether or not a variance should be granted.
That's right.
Because you don't have
And I would imagine that you'd have to
jurisdiction.
go back, and they would have to then apply for a variance if you ruled against what the HPC said, if you disagree.
Right. So the
Right.
question.
But they don't have jurisdiction, you don't have jurisdiction on the traditional land use application. That is actually a planning board jurisdiction because it's a subdivision.
The question that we've discussed, and I've discussed with the attorney for the HPC, is what the appellate powers of this board will be, whether or not it's, as Susan has said, a full hearing, or do we rely on the fact that they've had a hearing already at the HPC level with evidence and testimony and neighbors, and so that we're only asking whether or not what the HPC did was arbitrary, based on their own rules.
Right.
Which I haven't found any legal resolution to that question, but it makes a lot of sense that the hearing's already been held.
Oh, Susan, are you saying that this particular application wouldn't require a variance for the subdivision?
No, it would require a variance, but it's not in front of this board because subdivisions, unless they're
Oh, those
associated
variances
with...
come from the planning board? Oh, okay.
Subdivision, as long as it's C. If it's subdivision with a C, it goes to the planning board.
This is an unusual situation, I would say.
Yeah, and since it's all new for us, we're kind of feeling our way along.
So for the purpose of this board right now, a decision, if it's not actually determined for us legally what sort of appellate process we exercise, we need to decide whether we would grant, if the appeal did come to us, we would grant them a full hearing, kind of like we do when they appeal a zoning officer's, because a zoning officer's decision is not a full hearing. The zoning officer just says yay or nay, and then they come before us and we hear them and take testimony. This is different. They've had a full hearing before the Historic Preservation Commission. Then do we then offer them another full hearing, or do we exercise what I assume judges do in appeals? You rely upon the record, and it's a more modest review.
But, yeah, there's still two questions, assuming you're relying on the record, we do that. Is that a hearing de novo on the record, or is that a hearing we just decide if the Preservation Commission acted arbitrarily? I mean, that has to be answered. I don't know what the answer is, but that's the question.
I'm not sure of the answer either, but it seems as though, from everything I'm hearing, that the appeal is about to come in, that the applicant wasn't happy with what happened at the HPC, and that they do intend to come to the zoning board and has asked how to make that appeal. And since there is no form yet for that appeal, I simply told them to make sure they notify the zoning board what the reason is they think they should have grounds for appeal, and do so within as quickly as possible. 45 days from the decision. And that decision is, I don't know if it's 30 days old yet, I don't remember. It's probably less than 30 days.
Are you saying in effect that this zoning board has the authority to overturn a decision of the
Sure, if you
HPC?
have appellate review, you have the authority to overturn.
Yeah, but we need to know the standard of review.
Yeah.
I don't know.
What if
How do we get that answer?
I'm assuming it's arbitrary, capricious, unreasonable, which is the usual standard for administrative.
Well,
Okay, so it's not a hearing de novo. What happened, what's the standard when somebody doesn't like what we do, and instead of going to Superior Court, they go to the trustees? What do the trustees do? Is that a hearing de novo or arbitrary and capricious?
They can only do that if this board grants a use variance. The South Orange ordinance allows an appeal to the governing body.
And what, yeah, and what's the standard?
And it's never happened since, as far as I know, but.
Well, it is. I went to the trustees, and the
Oh, you did?
trustees affirmed.
Oh, you did?
This was, 30 years ago.
Right. Did you have a full hearing?
What was the standard?
No, we didn't, we certainly didn't have a full hearing.
It's just on the record below.
But I don't remember if they if they had a de novo on the record, or if they were just doing arbitrary and capricious. I just don't know.
I don't know I don't know what the standard is there. I'm not even sure what the standard is in this instance before, so I'm going to look into it.
You've always been a troublemaker. Ms. Grove?
And I would recommend, at the very least, I will make sure that with Jetta, that all of you have a full copy of the ordinance establishing the HPC, which establishes all the basis, as well as the ordinance that set forth the local landmarks that's complementary to the HPC ordinance, the original one. So that you at least have that and can read that and see what the standards were used in terms of what the HPC did.
Thank you, that would be very helpful.
You have those, right?
So
Ideally, electronic would be good for me.
could you send those out electronically?
Yes.
Great, that would be very
Pat,
helpful.
how are you going to decide, I mean, are you in a position to decide the procedure here, assuming they do file, or do we need to recommend or decide tonight how we want to handle this?
Well, we're in the lucky position, fortunate position, of not yet having to do it, because we haven't gotten the appeal in yet.
Right.
So I want to try to find out what I can about what the law says in this regard, whether or not it has to be in the
So
ordinance.
they need to hit a deadline in the ordinance of 45 days.
Right, to appeal, and then we would process that appeal, but our ordinance is,
How long do we have to process the appeal?
I don't know, but I'd imagine we'd have to act within, I don't know, I haven't looked at that. Obviously, you can't just sit on it.
Right. I mean, my point is, well, it hasn't happened yet. If it looks like it is going to happen, I just wonder if we need to make some choice tonight.
No, I think, well, you could, but I would ask for an opportunity to see if I can find some
Yep.
direction.
Yep.
Okay. All right, so we'll wait to hear from you, Mr. Dwyer. Any other questions on this matter? Okay, Mr. Adler, you had wanted to bring up at this meeting the question of the 10-day submission of information.
Yeah.
This is something we'd talk about in open meeting.
What's that?
Yeah. Go ahead.
Oh. Yeah, just in general, we get these good reviews from our planner, and on a completion hearing, as we're doing tonight. And what the paragraphs say is applicant has not submitted whatever required document was required, but I don't object, and we go along with it, provided they're given to the board 10 days before the hearing. And my first reaction is that the applicant should have submitted it, but didn't. Okay, I don't want to hold up their hearing, but on the other hand, what happens sometimes is the applicant maybe gets it to Jetta, if she's not sitting there. I mean, it doesn't go out to us until sometime later. It doesn't go out to Susan until sometime later. So her final review report may be late, and most of us are busy people. I'm not, but most of us are. That leaves us short sometimes with the papers, and there's no reason for it, so I would like to extend that time. In connection with that, and looking at Ms. Gruel's report for this South Orange Avenue that we're going to do tonight, item 18, the applicant has not submitted photographs of the property. The applicant has stated that photographs will be presented at the public hearing. What happens at the public hearing is the applicant gives photographs, somebody is testifying, photographs are being passed around back and forth. You can't concentrate on what the witness is saying, and it's just not the right way to do it. So I think whatever is going to be submitted ought to be submitted in a timely fashion. If they can't do it when they submit their papers, which is what they're supposed to do, then at least give us the photographs and everything else, X number of days, so that everybody doesn't have to do everything at the last minute. That's my point.
I'm not on the completeness case, so I wasn't particularly paying attention if stuff came in late. Did something come in late, within 10
he's speaking
days?
in
Some things
general.
didn't come in at all. right?
Right.
Some things, as was just stated, they'll be submitted 10 days prior to the actual
Well, we've
hearing.
always done that.
Right.
That's right.
but
Yeah, we
this is-
have.
And the 10 days has been our choice of a reasonable amount of lead time to get the kinds of documents in that we are asking for.
Not really, it's a requirement under the MLUL that docs be on file, initial docs, when you file the application, must be on file for the public to review 10 days in advance of the hearing
14
in order for the board to have jurisdiction, the same way the notice has to be
Right.
published. So most of the time, boards will follow through on that. Whenever there's going to be changes, they ask that they be submitted at least 10 days in advance.
Right. But there have been instances since I've been on the board where there were particularly material documents that we asked for, parking studies and traffic studies, where we asked for more than 10 days because they were complicated, right? There are other times when
Sure.
it's something, like, a letter of tax compliance, something where frankly it's a tick in the box and assuming it's there, 10 days is fine. I guess my view is that this is why we now have, and have had for a couple of years, a formal process of completeness. And if there is something in particular that we think we need more time on, we can ask for it at the completeness hearing. I don't, given most of the things that come up in completeness hearing are relatively mundane, I don't see why we would make a blanket change of 10 days. I think you're right. There are times when certain types of things we may want to have sooner, and we can ask for that as part of the completeness hearing. That's the purpose of that hearing.
I guess if I may follow up on that, Mr. Parlapiano, Mr. Adler, what you're getting at is if we say 10 days, we want it by those 10 days, so then we can get it to our planner, so she can comment on it and get it back to us within at least several days left for us to look at it. And what we certainly don't want to have happen, which I acknowledge has happened, and I let it pass. I remember one recent case that I'll try not to let happen again was when a very savvy expert presented material photographs on the day of at the actual hearing, and he could have presented these things well in advance, and he did it, and I think he did it absolutely on purpose.
No.
You're left, you can't pay attention. So that should not happen again. But I think the 10 days is, if it's not in municipal land use law, it's generally worked if we've held people to it. I think we have to hold people to it if it's important.
Okay.
10B, any maps and documents for which approval is sought at a hearing shall be on file and available for public inspection at least 10 days before the date of the hearing during normal business hours in the office of the administrative officer.
So
That's at least 10 days. Didn't that say at least 10
Yes,
days?
it did.
That's a minimum.
At least 10 days.
But if they're asking us to approve an application for completeness that's not complete, we can certainly ask them to do the work and get it to us earlier than that.
That's right, and that's the purpose of completeness hearing, and if there are particular documents, an item on the checklist that we're concerned about, I think that's the right place to talk about it.
So we'll do it individually then, you're suggesting? Okay, I can live
Ms.
with that.
Gruhl?
I understand the concern. I'm wondering whether, because if Jetta isn't there, it comes in 10 days, and then it's another couple of days to get it out to everybody, whatever. Maybe a 14-day period provides that bit of flexibility there without creating a major hardship. And yet at the same time, it provides a bit of opportunity for everything to get out with a couple of days flexibility.
That's what you would recommend, 14
I'm
days?
just thinking
Is
that
that what other towns do?
they sometimes do that.
That's to account for weekends, so it's really 10 business days, which at max would be 14 calendar days.
It's 14 days. It's for the situation where something comes in,
Yep.
10 days. Then Jetta, let's assume she's not there or busy that day, and then she wants to get it out to everybody. That may be a couple more days of flexibility, of not being able to get it out, and then you don't have it for a certain period of time. I think that 10 days, 14 days, I'm just suggesting that that is another option.
Does anybody else particularly, does anybody want the 14 days, or does it, we can ask for 14 days, we can ask for that.
I think it's an interpretation. 14 days is 10 working days. It's basically the same thing. And, you know, it's important for us to get these materials. It's important, as important, if not more important, that the public have access to these materials as well. I mean, it's, so I think 14 days is reasonable. It's fine.
Okay, well, you know, that's interesting, you said that 10 working days, that your assumption is 10 working days.
Yep.
Doesn't say that in the,
No.
No, and
we-
it
we
doesn't
could
work
bring-
that way either.
We could bring clarity to that.
let's do that. Let's make 10 working days, or 10 working days. We have that discretion, don't we?
Yeah, that way if a holiday falls in or something like that, it won't count on
You know, what I think is the bigger problem that I think I've been, that I've lapsed on is, these need to be not only before us, but they need to be in the office. So if people are presenting things to us on the day of an application, then the public doesn't have a chance.
That's correct.
That's the bigger problem.
That's in my opinion. I think that these should automatically be bumped to either a later date or something as soon as that grace period is passed, and not by us, but by the office, by the administrative staff. If they don't receive the materials in the time frame that they're supposed to be in, then we won't hear that. And that certainly will put these people in line.
I think we have to, I think there's a distinction between the completeness process and the hearing process.
Okay.
Because there is a great deal of flexibility and completeness about, if it's not yet deemed complete, the board has every right to ask for more information, and if they haven't provided everything in the checklist, they're not complete. But once you start the hearing, you are obliged under MLUL to make a decision after a certain amount of time, unless they haven't provided all of the information relevant to the application to your satisfaction, in which case you can ask them, don't you want to adjourn this and provide us more information? Because otherwise, if you force us to vote right now, we're going to probably say we're going to deny because we don't have enough information without prejudice for you to come back. So the applicants always extend because they want to make sure they give you what you want. But I think if you're going to build in that extra period, I'm not saying that it's not a good idea for completeness, but I'm saying during the hearing process, it's certainly, you know, we are under more of a time frame schedule, and I think if they get the information to us at least 10 days in advance, that's great. We also know, as Rusty has said, that at times they come up with something at the hearing that said, I just drew this, I just took this photograph, and if it's not necessarily overwhelmingly detailed and needs to review by our professionals, I don't have an objection to that being submitted as an exhibit at the hearing date.
Right. Well, the weird thing about that is that the public then doesn't get the benefit of seeing this in advance of the meeting. So members of the public, yeah, but the board at least is here. Members of the public make a decision whether to come to a meeting based on the materials that they look at in advance. Yeah. And if they look at materials and there's some parts of it that are missing, I mean, those things are brought in during the hearing, then...
I disagree. I think that,
is that right?
If you have an interest in the outcome, you're going to show up whether or not that photo is in there.
I'll also tell you that I appear before a lot of boards, and while everybody makes their best effort to get everything in, there's a rare application when you don't have something that you bring to the meeting.
Right.
Now, a planning report that is someone's giving testimony on for a use variance, that's not photos of the building next door. To me, that's a much more important document, and I would agree with Rusty that that should be the kind of thing that we kind of put our foot down with. But there are some things, for example, a color rendering of a building. You may not submit that as part of the package, but you may bring the big picture to bring and put it up on an easel and have it as an exhibit. I wouldn't say that you would have to have that.
No, I would agree. I mean, that doesn't substantially change anything.
Right. So I don't think we can make a blanket statement, but I think we may have to be a little more rigorous about the things that we let get dumped on us at the meetings. Traffic study, planning studies, those kind of things.
We've had at least 2 traffic studies
Yeah,
dumped on us.
that was my mistake. That was, And I certainly, if I'm falling asleep and that happens again, certainly somebody can nudge me in the ribs, because I'll try not to let that happen again. So those are the things I'm concerned about, but so we want to make 10 working days? I still think people are
So
going
then-
to slide.
So then what you're saying, we're gonna have a checklist that Jared's gonna be responsible for. As soon as the checklist is incomplete, Jared's then gonna call Rusty or send a note, guess what, this guy can't make the meeting as scheduled, we have to move him to the next date? Is that what you're gonna
Well,
do?
let's say, for example, we have a list of things that we come up with on South Orange Avenue that we want.
Sure,
I would say that we schedule them for the next meeting contingent on having that list of 8 things in the office 10 days before.
Well,
sure.
I think if you look at the,
And then, if it's not,
They,
Jared makes the call,
they're not on the
they're
agenda?
not on, oh, no problem.
that's true
But what
today.
I'm saying is that
That's true,
you,
yes.
you have to let them know.
Right.
You have
Correct.
you have to complete the checklist.
We do let them know,
Yeah.
we've just not always held people to a standard, because like Mr. Don has said, sometimes it's trivial stuff. So even as I'm apologizing for big lapses, some stuff, I'm not going to hold up if there's a tiny trivial piece. But yes, that is in place now, and we can hold them to that.
All right.
Well, look, we did this, look, we got tougher with, Fairview. We gave them notice. They wanted an exception, and we said no. So I think we've progressed in that manner.
I'd prefer a strict 14-day standard, because 10 working days can be ambiguous, because what 10 working days for some is not 10 working days for others. There's religious holidays that some people observe and some don't. There's not working days. And I think that the 10 working day standard is more subject to ambiguity than a flat 14-day standard.
Does that make sense? Makes sense to me.
Me too.
Okay. Do we have any,
That would be reflected then in higher rules memos, completeness memos.
so when we say that we're going to call something complete contingent upon something being submitted, that then has to be submitted before 14 days of the actual hearing or the actual application. Right.
Yes,
That's
all we're
what
doing
saying.
is changing what is in the conditional approval of completeness to say 14 days rather than 10
Yes.
days. That's all we're doing.
Okay. Does that need to go on the checklist, Ms. Davis?
Oh, God.
I don't think it's on the checklist. Okay, so we'll just operate by that way. Okay. Next item for business, I think now, unless there's something else, I think I've covered about, we go into closed session.
Well, should we do the completeness review first and then go?
No, we're gonna go into closed session, then I'm going to recuse myself.
Oh, right.
Okay. We're going into closed session for the purpose of discussing ongoing litigation. The contents of the meeting will be disclosed once that litigation is resolved.
Are we gonna pull the curtain off? What are we gonna do?
I'll walk out here.
Just going to the theater.
Okay, we're back in session, and at this point, we're going to move on to the completeness hearing for South Orange Dental, at which point I'm going to recuse myself, and Mr. Don will chair the meeting. Thank you.
Okay, so we should all have the packet for 481 South Orange Avenue. The items I have are the drawings, Casey and Keller drawings, drawings by the architect, the application, a letter that came from Mr. Friedland's office, which was attached to an Essex County Planning Board letter, which responds to one of the items in the planning review, and then the planning review, completeness review from Ms. Gruhl that's dated March 26, 2014. Those are all the documents that I have. Bob?
What's the letter from the attorney?
Jerry Friedland said a cover letter with a copy of a letter from the Essex County Planning Board saying that they did not require a submission. So it was just a cover letter.
Today.
Okay.
Was that part of the application?
No, it came separately.
Oh, okay, because we have not seen that.
Right.
So,
That was
Okay.
emailed after the application was
Yeah.
filed.
Oh, the email.
So just, there's no one, the applicant is not here, they're not required to be here for the completeness hearing. So generally, what we do here is that we go through the application. If anybody has any questions, we ask them. If there's information we want, we make a list so that Mr. Dwyer can get in touch with the applicant. And typically, we go through Ms. Gruhl's report, because she's tasked with going through the checklist and flag the things that aren't in compliance with the checklist. A summary of the project is that this is for an existing property at 481 South Orange Avenue, which currently is used as a office with also a residence in the unit. So there's office and residential space on the first floor and residential space on the second floor. The application is to basically convert the entire building to office use. So there's no exterior changes, no changes to the footprint, no changes to the outside of the building. All the work would be interior, but it would be a change from a mixed office residential use to all residential. The house sits on the corner of South Orange Avenue, and I believe the side street is Elm Court. So the residential entrance faces Elm. The existing dental entrance now faces South Orange Avenue. The driveway access is only off of South Orange Avenue. There is no vehicular access off of South Orange. So that's generally the scope. If we want to go through Ms. Gruhl's March 26th memo, we could go down the checklist of items that she sees as outstanding. I had a couple things marked on here that might be helpful for the applicant to clarify. One of the things is on the variance list, on the parking. It's page 2, about halfway down. There's an item that says 6 spaces are existing to remain, whereas 20 are required. I think it would be helpful if they gave us some sort of breakdown of the parking requirement now. In other words, there's a certain amount of the house that's used for office now, and there's a certain amount that's used for residential. That certain amount that's used for office probably generates a parking demand of X cars. They're now asking for an increase. I'd like to know what the increase in the parking demand is, because it's not a total increase, it's sort of a net increase. Because there's a non-conforming condition now, I'm assuming. Because the six cars that they're parking are kind of stacking in one behind another. They're not even really legal parking spaces.
and actually, that goes to your comment, Mr. Chairman, acting chairman, whatever, is that on number 19, regarding a parking impact assessment, and that clarifies, that should probably be, if the board agrees, should be
Yeah.
part of that assessment, because we had the same concern as to how the parking impact what was the parking related? How was it going to be addressed?
Right, well, not to skip ahead, but much like the property that we, at 7 at Fairview, I think we do need some evaluation of where people are going to park,
Yes.
you know, and what the parking environment is around there, because certainly the patients and staff are not all parking in those 6 stacked parking spaces.
Yes.
So, just if you could clarify your question, because there is a zoning table on the site plan, page 2, the plan submitted, that says required, has a required column, and it talks about parking off-street, and it describes how they came to the 6. Does that answer the question that you had, or?
But I don't see how the existing and the proposed can both be 6.
They're not changing it.
Yeah, there's not anything parking. I think but that's the kind of as-is statement of fact. I think what you're asking, and Susan, you're asking is how do you propose to handle the working load of this larger office day to day from a parking period? Are you planning to use street spaces? Are you planning to have the professionals park in back and then have patients park on the street? What are you proposing, right? So we certainly need testimony about that.
Correct.
You know,
Correct.
The question here would be, are we asking them to submit some specific parking analysis documents 14 days prior to the hearing? And I think we should, because that is going to be a seminal question in this case.
Yes, absolutely.
No, I get it now.
So do you want to go down the land development checklist, starting on page 3 on Ms. Gould's report? We can see if we have any issues with any of these items. The first item always makes me a little nervous now that we have these deed restrictions. Do we have to get involved with that, or is that something that we don't, if there's a covenant on the deed, from what I hear, that's not something that would impact our review of this application?
I agree, Mr. Chairman.
Okay, good.
But if that's true, why is it on the checklist? I just don't understand
I
this.
think it's a holdover from the prior checklist.
It does.
Well, there are situations where there may be easements or conveyances that are just part of the application. And that's what I believe is the intent, is not deed restrictions as such, but conveyances, again,
We want to confirm title, of course.
deed restrictions, because it's more than,
Yeah, but even ownership, we're granting a variance to the property, not to the owner.
But you have to have authority to bring the
Yeah,
application.
yeah, that's true, okay.
Okay. Next item is signed utilities. I would assume since this is an existing building, we don't need that. We're not looking to, I'm assuming that the existing utilities are already connected.
I guess it might be an issue if they were adding a lot of bathrooms or something.
Item 11, it's interesting that they already have the letter from the planning board. I guess since they're not changing the driveway, the planning board's not interested, so we can sort of strike that since they've made the county planning board application and they said that they're not interested. Health Department, item 12. Again, I don't know if this is applicable, but again, it is, if we do approve it, it is a condition of approval.
It should be, yeah, dentist office should be.
Item 13, I'm assuming since there's no work being done, that there's not a soil erosion and control plan required. Same thing with 14, DEP or DOT. 18, I think it would be very helpful to get photographs in advance to look at, because it's a very odd property, and I think it's important to understand the context. If you've been by, the house actually fronts Elm, but that's not the front. That's not what nobody would be going in and out of there. If you look at the plan, the front door exits through one of the hygiene rooms. So I think it would be helpful to see photographs, and not brought that night. It would be good to get them in a package.
They could email them as well.
Right. Item 19, I think we've already talked about. I think we need to give them some direction on this parking study. I think the Fairview parking study was actually a pretty good study as far as the area in which they did and what they sort of documented and when they documented. I thought it was, whether you liked or didn't like the application, I think it was a good piece of information for us to have. And I'd like to see sort of the same thing for this. A 250-foot radius seems to be a pretty good, a reasonable area for someone to walk. Especially since the parking there also is time restricted.
That's 14 days prior to the public meeting.
Right.
So we'd be asking for a parking impact assessment that covers a 250-foot radius from the property.
I think that's yeah.
I'm happy with that.
Item 20 is not submitted. No conditional uses are submitted. Okay, so we don't have to deal with that one. 30. I think that this, obviously, to me, the schedule has got to be correct and completed. So that they should go through that, because just this, even the one item we looked at, which was the parking count, was not correct because it listed the existing parking and the proposed parking and didn't really address the required parking.
That's
So-
right. You need to show the different uses.
Right, so. Now we get to number 31. Does this project have to go to the HPC?
It is in the district,
It is in the district.
so we would automatically be sending it to the HPC for their comments.
There are no exterior changes proposed, but I think as a rule, it does have to go to them, right?
I believe on the ordinance it goes.
It's an advisory,
Right, it's an advisory opinion, correct.
correct?
So we'll send one to, actually, I think we decided that it was going to be sent upon completeness, right, Jetta?
Yeah.
In which case, any of the things that we talk about that we want to see, we might want to include in that, which gets sent. So if there's a photo requirement.
Whatever comes in goes to them as well.
Item 33, that's again, updating the plans. The setback line should be included. 35, I don't believe that that's really applicable here. 36, well, I guess, do we need a statement that they are served by public?
I don't think we've ever asked them to.
Okay.
You know,
require
just,
that.
just to go back to, there was one of these items, item 14, talked about DEP approvals.
Right.
And if they get an approval from DEP, then a lot of this stuff goes away anyway. So, I mean, I don't, some uses, they might have waste issues that need to be dealt with in a certain way. Dentist's office might fall into that category, I don't know.
Yeah, there was a TWA issue in Seton Hall's application. Well, that's the planning board. The planning board application by Seton Hall for the University Center involved TWA approval because of the size of that project. So there was utility approvals that had to come from DEP.
The next item is landscape plan. What's the feeling about landscape plan? It's really not addressed at all in the site plan that we have.
I agree with the planners. The recommendation that we should get one.
Right, even if it's just showing what exists, because there is a
There are
lot of
trees.
planting, there are a lot of planting on elm.
It looks like there are trees from the satellite photo, and there are none shown on the plan.
Yeah, I would think that that would be helpful to get that onto the drawings.
There's one shown.
And I don't think 39 is applicable. Okay. So I think we've identified a number of items that we wanted. I hope somebody was writing them down.
Yeah, it's essentially what what the memo
Yes.
highlights at the end under comments, right? One point I'd make about the parking assessment is the applicant, we should let them know that we're going to have a significant focus on parking, that our reading of the law says they're way under on parking, and that this is a material concern for us. I think, I always get a bit concerned if we get too prescriptive on what we want. I think you're right, 250 is a nice radius, a walking radius, if they're going to be using, we're assuming they're going to be using public parking pretty heavily, and so that would make sense to me. But I don't know. I mean, they might come in and say, we rented space in a lot down the street, and we're going to, I don't know, that may have nothing to do with 250, right?
Right.
So I just think, we could say, this is going to be a concern. We would recommend that if you're planning to use on-street parking, that you give us a lot of information about that. The 250 radius makes sense. But not prescribe the answer.
No, absolutely, absolutely. But I would also not want to get a parking study that gave us a count of 1,000 feet away, knowing that no one's going to use them.
Right.
So having been through that, Bob?
I have something else.
Go ahead.
Okay. I think it's important. With the application, the applicant submitted,
Oh, right. Go ahead.
gave an explanation of the history of the property, including, interestingly enough, Patrick, an action in Superior Court to reverse the Board of Trustees' reversal of the Board of Adjustment. So it's been done. But here's the thing. They attached the judgment and a couple of letters that are just covering letters. But the important thing that we should be seeing is what the Board of Adjustment said. The Board of Adjustment's recommendations and its determination and its resolution, and I guess a copy of the complaint to Superior Court. So that's, I'd also, I guess, like to see what the trustees said, although I'm more concerned with what the Board of Adjustment said. Who writes this letter to the applicant? How does the applicant know what we're thinking?
Well, in completion hearings past, the board has said, all right, we agree with the comments from our planner and we'll rely on her letter. But on occasion, I've been asked to make additional requests. So it's up to the board. This one has seemed to have more requests than I can remember in recent history, but most of it's based on Susan's letter right now.
Right.
Sure. Except that
To the extent that we got into the legal end of it at the end, I think that would probably have to come from me, but I'm comfortable with Susan emphasizing what her letter says. I don't know if you want another completeness letter from her. I think, now I think it through, it's better to have a cover letter that says they looked at the completeness letter and this is what they want you to focus on in addition to what she's mentioned.
Right.
Yeah. And I think obviously, if we want them to have the stuff to us 14 days in advance,
It's got to be done.
we got to get it to them quickly. Otherwise, they're not going to have it in time for the May meeting.
hearing.
Although the May meeting is a little
All right, it's late.
further.
It's late.
It's almost an extra week.
It's the 8th, I think.
7th?
Thursday?
Thursday.
Why is it Thursday?
Thursday, the 8th.
It's so packed schedule.
Oh, so packed.
So
Okay.
are you going to draft that
I will.
letter? Okay. All right. So based on that list, are we willing to give them a conditional of completion and put them in line to get on, assuming that we get all that stuff
I have no,
in the timeframe?
that's
Yes.
fine with me.
No problem.
Do we need to, do we vote on this? I forget. Or just a consensus?
I think it was a consensus before.
Okay. Does anybody have any
Anything else?
comments? Anything else? So we will, Mr. Dwyer will draft the letter with the items that we're looking for, we'll put them on conditionally for May, assuming that they get us the stuff in 14, within the 14-day time period.
Okay.
And I guess they will be second in line behind Seton Hall, assuming Seton Hall goes ahead. And then we'll have to deal with the scheduling issue, but let's jump off one bridge at a time. Okay. Any other items that we need to talk about? None being seen, I guess we're done for the night. Meeting adjourned.
Well done, Bill.
Bill, you did a great job.